sorry you were stuck here.
Yeah, I know, but happy Pride, happy Pride. I'm like, man, I haven't missed a Pride in a long time.
Me neither.
So I'm like, always wear the shirt, I always wear Pride.
Yeah.
It's like, always do that. It's a bummer. It's so rainy last year down there.
It rained so much, I know. It was awful. I just wore a bathing suit top with my shorts because it was so rainy.
So it's like smart.
I might as well just
Yeah,
wear a bathing suit.
I had like a raincoat, but I ended up like, I sure was fresh by my mom went to, so it was really special. But yeah, I ended up giving her my raincoat, and we went up to Fountain. I always go to Fountain Square, and it was just like everybody's umbrellas were dripping right where I was. It was memorable.
Yeah, you know what? It was. Yep.
Definitely memorable.
Come sit up here with Zen instead.
I just want to come say happy
By the way. I'm sure you know.
You're like me. It feels like you want it now or just do more?
No, I think.
Yeah, I mean, there are events ones.
Oh, yeah. The parade. So I
have spray for stuff.
Oh, your sunglasses?
Yeah.
Oh, I'm sorry that you cried. I'll throw candy at you later? I don't think that's the same. I mean, I don't think that's the same at all. I'm so excited for my parents next week. But that's why I have the dress on. I don't wake up every morning. Just get dressed. So my mom's gonna need to bring fashion tape or something because the saying is it's like used to tie everything, but the husband court when the statute go ahead before I think and then before I yeah, I mean I don't know what happened to that dress. Maybe I stripped it in half. It's happened in life. But then it also has okay. I didn't hear anything. I was so often doing it like this. Right. You know what I mean? Like it's got. Yeah. I would ignore all the back and forth and just pick the final. Whatever the final. They don't have it. Give it to the one that's here. You know, if the worst thing. Oh, yeah, she's no wonder. Why didn't Mandy do it? I'm actually okay. Oh my God, you know what I mean? Like, I'm alright. You dressed up? I gotta take my back.
Yeah, why isn't she here? I'm like,
Why isn't Mandy here to learn all about this?
I know. I feel bad. Thank you.
Oh,
do you like my mom?
Ohio Station is you can walk in front of me through it.
Yeah,
and they give a formula.
I'd like to make a suggestion.
But then it gives
So I didn't say anything this morning. I was like, I started coughing.
Ohio, in a specific case, they gave us rendered Catholic pertains to products.
Right.
Okay. That's when they validated it.
Right.
But they didn't say that when I studied the part on personal injury and Bronco. No.
Then I wouldn't get too bogged down.
Just treat it as if it's capped.
Right.
Okay. And
then if you have the time, you can always say, yeah, but.
And I doubt they're even gonna.
No.
The other one was on the collateral study.
Yeah.
Where Ohio abrogated theirs. And then the Supreme Court said, we're invalidating.
The abrogation.
So are we still reducing then or not? Then it gives me the statute to reduce. Or state paid.
I heard notice at the far back of the classroom.
I can
you might have a row. Yeah.
Oh,
Yeah.
I was a back row crew.
Yeah. Yeah.
That's about as far back as I go.
As far as I'm concerned, I don't
think
really
it's just
know.
a line. Like,
No, I think that's
I
right.
think you're actually.
Yeah, I just thought if I couldn't see it, I'll get it right now.
Yeah, I think that's right. And, you know, again,
Yeah.
Ashley.
I mean, on the essay question,
I don't count.
really,
No.
That nuance, right? Okay. Thank you.
Okay, how are you? Good. I see the clock's not working.
I saw it.
I've been, no, I mean, unless you want to, I mean, there's no reason to. You know, worry about something. Saying something really dumb, then.
Where?
There you go.
No, I get it.
How are you?
You have to get away.
Well, it was just character.
Was she coming back? Oh, right in the screen.
I mean,
You both know you know.
You know, it's got to.
So I. You were gonna go on August 2nd, but I'm like, August 3rd. And we go 3 hours.
well, and then you get a yay and
Yeah.
for
For bar, taking the bar. Yeah, bar taking.
You're not coming.
Yeah, it was not easy, nice.
Yeah, because I was like, every time I go to the I was straight or three months they were like 3,000 dollars.
It will be good. They've never been.
I know.
So I'm excited to show them.
It looked like even if it was gonna rain, it was gonna be good. Yeah, I know. Yeah, because White Moon texted me and I said, look, I'm here. I'm working. I don't know what you're doing. So yeah, I think he and Sarah and Louise and Paul were gonna meet up.
Oh, good.
Yesterday, I'm like, I got dressed in like 5 minutes. I'm like, I don't care. I have to go to some guys.
All right, how are you? Good. Good to see you. Oh, you know, it's fun. Fun? Yeah, it's fun. Talking about sick bro, you know.
Good, that was just last night. You should be here.
Busy. I mean, I'm teaching, and then in the last week or so, scrambling around trying to get my section of this amicus brief working.
Oh, that's what you joined on the next with
Yeah. So I'm sort of now trying to put the brief together. The filing deadline for all the candidates July 3rd. Okay. So we've got about a week. But we're in pretty good shape, I think, and our focus is really on really kind of interesting stuff about sort of stuff I've been really research on. Sort of when we think about public meeting section of 64, what was kind of in the air in terms of transsexualism and all of that, and all the Jorgen and cross-dressing prosecution. So there was a lot of stuff going on that would lend itself to the argument that it's not right, these ideas are not sex. So, anyway, it's been fun. Yeah, well, it'll be once we get it filed. Yeah, and there'll be a ton of those for these cases.
Yeah, there were.
But this is like, no.
Garda.
Yeah. This will be like, and I don't know whether they're going to combine how they do all that. Or the cases all filed together or not.
Okay.
All right.
Watch out, Kelly.
Did you get the Commonwealth stuff? She said she was gonna email it, so.
I have the questions and the explanation in the notes.
No, it's it. I mean, there was a worksheet though. Like, not like a worksheet, but like fill in the blank.
Oh, okay. I think it's gonna be caught here again. So after I left here last time,
All right, good morning, guys. It's another Saturday. Thank you for coming out. Professor Harrison is going to do our civil procedures lecture today. Everyone, please give them a round of applause and thank them for being here. As always, I will have lunch after we finish up today. And I do want to remind you guys that if you would like another set of eyes on any essays or MPPs that you are doing for practice, please email them to me and I will grade them and give you feedback.
All right, thanks. Well, here we are. I'm sure you guys are sick of all this stuff by now, no doubt. But hang in there for another, month or so. What's the actual date? 30th. Okay. All right, we'll hang in. Before I get started, I really wanted to, because I don't want to cover stuff that you all already know. So what I wanted to ask first, are there specific civil procedure areas that you're finding you're struggling with?
Erie and also Joinder.
Okay. All right, Erie. All right. What else? Anybody else?
Preclusion.
Preclusion. Okay. All right. All right. Anything else? Okay. What about Erie? Just because I mean, here's the thing. Here's the thing on Erie, and I don't want to go too far here, but it's pretty difficult to craft a very good multiple choice question dealing with Erie. So, I mean, I'm not saying they won't ask an Erie question, but where the Erie question more often gets asked is in the area of, let's say, which conflict of laws rules are going to apply.
Yes.
So it's an Erie question, no doubt, but where you have, let's say, A from Ohio sues B from Indiana over an accident that occurred in Kentucky. And they sue, so we're greater than 75K, so we're in federal court. We've got diversity. We're in federal court. We're in federal court, let's say, in Indiana. A sues B in Indiana. Now, first off, let's just review a couple things here. A sues B in Indiana. Is venue proper here? Yes, why? Right, we've got one defendant, and it's where the defendant is. So where else would venue be proper? Kentucky as well. So either Kentucky or Indiana would be proper venue under the venue statute. Because remember that when we get a venue question, the thing to look at is, okay, do we have multiple defendants? If we have multiple defendants and they're not all from the same state, then 1391B1 can't apply. So that means we have to then ask, okay, where did the acts or omissions giving rise to cause of action occur? Well, here it's Kentucky, so that makes Kentucky a proper venue as well. So when you get a venue question like that, the first thing to look at is to ask yourself, do I have multiple defendants? And if I have multiple defendants, are they from different states? Because if they are, then where the defendants reside is not going to really matter for your purposes. All right, back to the question about conflicts then.
All right, so we sue, A sues B, federal court in Indiana. So the question then is, we know it's a state law case, right? We know it's a federal court sitting in diversity, so we know it applies under Erie, we know it applies state substantive law, federal procedural, right? That much we know. The question then becomes, whose state's law? How do we figure that out? Where do we look? Well, Claxton tells us that in order to figure that out, what we do is we look at the conflict of law rules for the state where the federal court sits. So that if you get this is the kind of multiple choice question they will often do in this area, your options will be Kentucky law applies, Ohio law applies, Indiana law applies, or then you'll get the actual correct answer that it depends on what the conflict of law rules of Indiana are to determine which state's law is going to apply substantively. Does that make sense?
But it could be any of them.
It could be any of them, but from the facts that you're given, these facts, you can't tell. The only way you can tell is if the question gives you what the conflict of law rule is in Indiana. That's the only way that you could, based on those facts, say it's this, this, or this. And more likely it's either going to be this or this. It's either going to be the law where the case is filed, or the law where the cause of action arose. This more often than anything. But you don't know that unless the question gives you what the conflict of law rule is. Because you're right, it could be any of these, but we have no way of knowing that. So unless they tell you what the conflict of law rule is in a particular state on the question, then your answer has to be, well, the only way we know which law applies is by looking at the conflict of law rules where the court sits. Questions on that?
I mean, it's the same if there's multiple defendants. Say if there's another one from Tennessee.
Yep, same thing. Because Claxton says, and it's an Erie question, because the Erie question in Claxton was, okay, we know, basic Erie, state substantive law applies. That much we know. The problem is, when we've got multiple defendants and a place where the cause of action arose, that's not any of the places where the court sits. How do we know whose state? Which state? And so what the Supreme Court held in Claxton is that we look at the conflict of law rules where the court sits. So that's going to be the answer unless they give you actually what the conflict of law rule is in the state, which they could do. I mean, they could pose a question that says, the conflict of law rules in Indiana is that it is the cause of action, that it's where the cause of action arose. That's the law that applies. Well, that assumes, obviously, that you know that that's what you're supposed to do. Because then the options could be, is it Ohio, is it Indiana where the court sits, which seems logical, right? You got a federal court sitting in Indiana, you would think, logically, they would apply Indiana law. But if the conflict of law rules for Indiana says you apply the law where the cause of action arose, then we're applying Kentucky law. We've got an Indiana court, federal court, applying Indiana law. So does that help? Okay.
So if there were other defendants from different states and A brought the cause of action in Kentucky, because that's where the accident was, then the answer would be Kentucky's conflict of law rules determined.
Right. That's where suit arises. And more often you're going to see a question like this, where you've got a cause of action that is not where the case is filed, because that's the trick, you know. And so they want you to say, well, it's probably where this court sits, right? That's the logical answer. That may be true, but unless you know the conflict of law rules, it isn't true. And what happens is people remember something about this eerie stuff in this Claxon case that says something about when a case is filed in diversity, something about the court, the law where the court sits. And so Indiana becomes the answer, which is wrong. So make sure that when you don't get tripped on that, when you see this kind of question, because this is a question you will see, where they'll do this kind of conflict of laws question on the multiple choice. Because, I mean, the other eerie stuff becomes really difficult on a multiple choice question to ask once you get beyond, well, is it state or federal law? Now, the other place where it will come is, are questions related to statute of limitations. State statute of limitations, we're in federal court, there's some difference between the federal service rule and the rule in the state as to when the statute begins. In all of those statute of limitations cases, the state law is going to trump. Because all the cases that you've read in Cipro say that. And because at that point, it's as outcome determinative as it can be. Because in those cases, if you apply federal law, which federal procedural law rigidly, then the case goes forward. If you apply state law, the case ends. Well, talk about forum shopping, you can't have that. So if it's a statute of limitations question where you've got this eerie issue, then it's always going to be state law applies. But beyond that, it gets a little difficult for them to do much framing of multiple choice questions on that. Other sort of eerie related questions, because I really do want to do what's helpful for you guys. Okay, let's talk about joinder then, because joinder and supplemental jurisdiction. That's where it gets really messy, right? All right, so let's kind of walk through. I shouldn't have erased that. All right, so we've got, let's say we've got an automobile accident. Those are easy. We have a 3-car automobile accident. All right, so we've got A decides then A is from, let's make A from Kentucky. A sues B from Ohio. That's all. So A sues B from Ohio, $75K, so we're in federal court. All right, now we think about the whole sort of joinder process. Let's do joinder first, and then we'll talk about how it relates to supplemental jurisdiction. So A sues B. What can B do at this point? What are B's options at this point, assuming service? What can B do now? Counterclaim. Anything else? Not quite yet. Maybe.
Affirmative defenses.
Yeah, you can file an answer, affirmative defenses, you can file a motion to dismiss, raising all of the 12B defenses. So we got a counterclaim. So if we got counterclaim then, we got 2 kinds of counterclaims, right? What are those? Compulsory, right? So we've got a compulsory counterclaim is what?
You have to do it or you wait.
And how do we know that we have one of those?
That's a good question.
Right. It arises out of the same transaction or occurrence. So, for example, A sues B for personal injuries in the accident and for damage to the car. B says, hey, I had personal injuries and damage to my car too. So B asserts counterclaim against A. And that one would be compulsory, right? Which means if B doesn't bring it, it's gone. What would a permissive counterclaim on these facts look like? Breach of contract, yeah. So let's say, unrelated to the car crash, B had contracted with A for A to paint B's house, and A screwed it up. So B also asserts then a counterclaim for the breach of contract. So we've got a compulsory counterclaim and a permissive counterclaim. Now let's say, before we get into, well, let's go ahead and do it here. All right, so let's say our counterclaim is also greater than 75K, because it's just in car crash and stuff. But let's say the contract for the painting is 25K. Can the federal court hear this counterclaim?
It has to have the supplemental.
Well, can it hear it under supplemental?
Yeah.
No. Doesn't arise out of the same transaction or occurrence. And it has, so if the federal court can hear this permissive counterclaim, there has to be an independent basis for jurisdiction for it. So if the paint job was, let's reverse it, 75.1K. Because remember, if you get a question on there, I can't say this enough, if it's $75,000 even, that's not enough. So don't anybody miss that question. But let's say this is $75,000 and the car crash counterclaim is $25,000. All right, so now, can the federal court hear this claim? The permissive counterclaim? Yeah. But not based on supplemental jurisdiction, simply because we have an independent basis for it. They're diverse, and it's in excess of $75,000. Can the federal court hear this claim? The $25,000 counterclaim? Yes. Why? Supplemental jurisdiction, because it arises out of the same transaction or occurrence, and therefore the fact that the amount is not met doesn't matter. Now remember, though, that when we're looking at these or other claims, if the diversity, if it's a question of the same states, then we got a supplemental jurisdiction problem. But if it's the amount, then the court can hear it. All right, so we got counterclaims under Rule 13. So, okay, then now let's do our third. Well, first, let's assume, let's see, where do I want this to be from? It'll get more difficult. Let's make C from Kentucky also. All right, so let's assume first that A sues B and C. Both of these can assert counterclaims, right? They're both defendants. They can both assert both compulsory or permissive counterclaims under Rule 13. But remember, if they are permissive, which means they don't arise out of the same transaction or occurrence, there's going to have to be an independent basis for federal court jurisdiction, which means it's either going to have to be diversity or federal question. Can B and C assert claims against each other? What are those called? Cross claims, right? So are there any limits on cross claims? Do they have to arise out of the same transaction or occurrence? Yes, they do. So cross claims, you can assert cross claims, but they've got to arise out of the same transaction or occurrence. All right, so, and again here, let's assume that B's cross-claiming at C is 25K. Can the federal court hear this claim? Even though it doesn't meet the jurisdictional amount? B's claiming at C. Yes. because it arises out of the same transaction or occurrence, and therefore supplemental jurisdiction allows the court to hear it. Now, let's go back to the question about the third-party joinder, which always trips people up. This is one, if you walk away understanding nothing but this, it'll be good. Because it's the one that they trick people on all the time. All right, so we got a 3-car crash. A sues B. Can B bring C into this case? How?
Joint for users, or is it indemnity for insurance, or?
Well, it depends, right?
Yeah.
It depends what the question tells us.
Oh.
Let's say, let's say that the question says, A sues B. B's decided that B is not liable to C, but B is not liable to A, but C actually is. On that basis, can B then bring C in because B decides C is who is truly liable to A? Can they?
So you're asking me if they want to bring C in to contribute?
Nope. Didn't say a word about contribute. I'm saying that
For life.
I'm not liable, they are.
They are, okay.
We're all three in the accident, but I'm not liable. C is, and therefore C ought to be here because C owes A. Can they bring him in? No. The only way under Rule 14 that the defendant can implead this third party is if it's under some theory, contribution, indemnity, guarantor, some theory that says if B is liable to A, C is liable to B. So if you get a question that says explicitly that there's no contribution in our state, then that ought to be a signal to you that you cannot bring this third party in. The only mechanism the defendant can add that third party is if there is some theory under which C is going to be liable to B for contribution. And that's usually that's the most common one that you'll see in these questions. Contribution and indemnification are the two most common, which could be an insurance company, because the insurance company is obligated to pay if I have to pay.
That's regardless of what state C is in?
Yes, doesn't matter. We don't care. Yeah, we don't care.
It only matters if we're talking later about like the plaintiff.
Yeah. We'll get there. But yeah, at this point, it doesn't matter. C could be from Ohio. Because supplemental jurisdiction, right? Because the contribution action arises out of the same transaction or occurrence. Because otherwise we don't have an obligation to contribute. Yes?
Does that apply to all the joinder rules?
Nope. Only to Rule 14. But there is no other joinder rule under which B can get C in, right? There's no other way. Now, what else could, yeah?
This might be kind of where Cherie was going. So if B impledes C and they're in federal court, it doesn't destroy diversity unless A sues C.
Now let's hold off on that one.
Okay.
We're not there yet. We're just worried about, right now we're just worried about Rule 14 impleter.
Okay.
So for Rule 14 impleter purposes, if these folks are from the same state, doesn't matter. Opposite state, same state, doesn't matter. Because again, supplemental jurisdiction allows the court to hear this contribution claim or indemnification claim because it arises out of the same transaction or occurrence. Now let's say though that our defendant here, B, says, as we said, C really needs to be in this case. what can B do to try to make that happen? What are B's options, if any?
We're talking about necessary parties.
Yeah. Under what, and how would we do that?
I shouldn't have volunteered.
Yeah, you did, you're in.
I'm here for a reason.
No, I mean, what? Okay, you're right. So how do we get there? How do we make that happen? What would that scenario look like?
Do you want me to explain how they?
No, I want you procedurally to tell me what that would look like when I see it in a question. Here's what we've got. We've got these two folks, A, B. We know we got three folks involved in this car crash. A sues B. B says, C really belongs in this case. We've already determined without contribution, there's no way B can just simply unilaterally bring C in, right? So what then does B do to try to raise the issue of required parties? Right. They file a Rule 12 motion. They say, look, hey, complete justice cannot be given in this case without C in here. Now, I will tell you that when it's joint tortfeasors like this, the court will never grant it. Never. But, for our purposes, for example, we can make the argument anyway that, look, there cannot, and the reason it never works on joint tortfeasors is that A can recover completely from B.
Oh, and the B sues.
If there's contribution. If not, too bad. B can then sue C for its own damages, but if there's no contribution right, B's got no right to go after C for what B had to pay A. So the only way then that this defendant, if the defendant says, hey, look, there's another party that has to be here, then under Rule 19, that defendant has to file a motion and ask for that party to be joined, arguing that they're a required party, which complete justice cannot be given unless they're here. Now and again, in a joint tortfeasor scenario, that really is never going to work. But for our example purposes. All right, questions before we bounce ahead? All right, so let's go now to the question that everybody was wanting to get ahead of themselves on. All right, so let's say then B does bring C in for contribution under Rule 14. So B basically says, look, there's a contribution statute in our state that says that if I have to pay A more than my fair share for the damages, C then, I have a cause of action against C to seek contribution, reimbursement, for the extra portion of the damages I paid. Now, if I have this contribution, do I have to bring it? No. I can bring it in a separate action. I mean, to your point earlier, Kevin, I mean, that if I say, I'm going to wait, and then if I lose, then I can sue C separately for a contribution action, assuming we're allowed that in our state. And again, we've already said that this is going to be under the court's supplemental jurisdiction, even if they're from the same state, or even if the amount is too low. Now, where we get into trouble, though, is A then says, okay, now that you have this third driver in the case, I'm now going to assert a claim against them. Can the court hear that claim under any theory? No. Why? It destroys diversity. Because if you remember now we're going to go statutory a little bit here. 1367A says basically, the court can hear any and all claims that arise out of the same transaction or occurrence. That's A. B then says, though, except for claims by plaintiff, and when the statute says plaintiff, it means the original plaintiff. Not a third-party plaintiff, not a fourth-party plaintiff, it means the original plaintiff. Except claims by plaintiffs against parties, against persons, made parties under 14, 19, 20, and 24, where it destroys diversity. So in this case, we have a claim by a plaintiff, right, against a person made a party under what rule? Right, under Rule 14. Which means, of course, that now we've got a claim by a plaintiff against a person made a party under 14, and it's a violation of 1332. Because they're from the same state. That would also be true if the jurisdictional amount wasn't met.
But the court is still here.
Oh yeah, the rest of it's fine. Yeah, the rest of it's fine. It just means that the federal court, and it doesn't mean that this claim is lost, right? It just means that A's got to take this claim to state court. They just can't do it in federal court in this case. So the one thing you want to look for if you've got a question that's raising an issue about supplemental jurisdiction, or seems to be, is the claim in question a claim by a plaintiff against the person made a party under any of these rules? Because if it is, and it destroys, and it violates 1332, in that it is either non-diverse or doesn't meet the jurisdictional amount, then the court can't hear that claim. Does that make sense to everybody? I got that. Now, here, where it gets tricky, which I don't think they'll do, but just so you have it in your... What if C asserts claiming it's A? Okay, C asserts claiming it's A. Can the court hear that claim? We just reversed the error. Yeah, because now, even though they're non-diverse, it's not a claim by a plaintiff against a person made a party under 14. It's a claim by the third-party defendant against the plaintiff. That one's fine under supplemental jurisdiction, even though they're non-diverse, because it's not part of 1367B exclusion. Now, the one thing that they should not do to you, but just so you'll be aware, because it's an unclear answer. What then if A has a compulsory counterclaim? So if A has a compulsory counterclaim, yeah, C asserts claim against A, and then A has a compulsory counterclaim. Well, they can do it, but can the court hear it? That's the issue. Isn't it still a claim by a plaintiff against a person made a party under Rule 14? So under a strict reading of the statute, the court can't hear that claim.
So because you just said compulsory, then in order to make sure that they preserve that for themselves, they would have to file that in the state court.
Well, yeah, or the court in its equitable power is going to have to somehow ignore the statute. Because under the strict reading of the statute, even though there's no exception under 1367 for compulsory counterclaims, this is still a claim by a plaintiff against a person made a party under Rule 14. And therefore the court, under a strict reading of 1367, cannot hear that claim.
Which would be the correct answer.
Which would be the correct answer. That's what I'm saying. So if it gets, if you see anything, I mean, that would be really mean. Because the courts are really all over the map, but a strict reading, a clear reading of the statute is that that is excluded under the statute.
So I have two things.
Yeah.
1367 statute, that is covered in supplemental.
Correct.
jurisdiction. And then that 14, 19, 20, and 24, those are the exact joinder rules.
Civil rules, not all of them though.
Okay, so then my next question is there a way that if it doesn't take them under one, you kind of write them on the board?
The joinder rules?
Yeah, and then just check them off.
Sure.
With the joinder rules kind of thing.
We've already talked about some, 13 counterclaims, right?
And pleaders and necessary parties.
13 counterclaims, and also cross claims, right? Which is also covered under 13. 14, third party impleader. Um, 15 is not really joinder, it's more amendments. 18, joinder of claims, right? And remember, 18 says I can join as many claims as I want I've got against the defendant. Even if they're unrelated. We still have to have subject matter jurisdiction, though. But I can join them all. 19, necessary parties. So those parties with that complete relief cannot be granted unless they're in the case. Those are going to be the kinds of cases where there's property rights at issue. For example, where if we're in a dispute over ownership of the property, but you have a claimed interest in the property, well, there's no way really to adjudicate our dispute over the interest in the property without you being in the case too. Because if it's adjudicated in my favor or your favor, your interest is not protected. So in a case like that, you become a required party to be brought in the case. And the court has a choice at that point when there's a motion, Rule 12 motion under Rule 19 to either order the party to be brought in, or if the party cannot be brought in, to dismiss. Now think about a circumstance where the party couldn't be brought in. What might that look like?
Are they breaking diversity?
Right. Where diversity is destroyed, or where the court doesn't have personal jurisdiction over that other third party. So in those cases, the court's then going to have to say, can we craft as complete a relief as we can while not impairing your interest without you here? And if the answer to that question is no, then I've got to dismiss. So, okay, 19, 20, just your basic joinder of parties. Uh, 23, class actions. 24, intervention. Okay, so those are all the joinder rules. So when the statute talks about 14, 19, 20, or 24, it's talking about third party and pleader, those brought in as necessary parties, those joined under Rule 20, and those who have intervened. So this is kind of where these questions sometimes will get tricky on the supplemental jurisdiction questions, this stuff. So always ask yourself as you're going through and you're reading through the question is, how are these parties brought into the case? Or if they're asking you, can this party be brought into the case? Then think about what position are they going to be in? How are they being brought in? Because the answer may well be no, they cannot be. Because every party can't be brought in if there's no theory to get them in. Yes?
Sorry. And just to be clear on 14, they only come in under a theory of contribution or identity?
Indemnity, contribution, guarantor would be another. insurance with insurer, some theory, but the theory has got to be one where if you, the defendant, are liable to the plaintiff, I somehow am liable to you. Not to the plaintiff, but to you. So it can't be simply that it's a joint tortfeasor. And the way they word these questions often will be just that. That, you know, A, B, and C are involved in a car crash. A sues B. B says, or one of the others, which I probably, one of the, you know, where B says, I'm not really at fault here. C is really at fault. I'm going to bring C in because C really is the one who's liable to A. That's not proper under 14. And that's the kind of question that you will see, because they love playing that game.
What is the difference between permissive joinder of parties and a party intervening?
You mean...
So between Rule 20 and 24.
Well, the real question is, here's where the difference is. Intervention, because joinder of parties means I make the choice as to whether I join you.
Okay.
Under 20. Right? I mean, for example, A can choose to join B and C, right? In this case. But let's say it's back to our dispute over property. Let's say it's a dispute over property. A sues B. C says, wait a minute. I've got interest in that property. I want to get in that case. The only way C gets in that case is by trying to intervene. So when we think about intervention, we're thinking about a party external to the lawsuit who says, I have an interest that's not being protected, and I need to get in that case. And that's where intervention Rule 24 comes into play. Okay? Other questions about any of this stuff?
I don't want to go backwards, I just want to make 100% sure about something. If B brings in C,
Right.
A cannot sue C on an original claim unless it wouldn't destroy diversity, or how did you say it?
Wait a minute now. You mean if we've got A and B the original suit, right?
Yeah.
B then third parties in C under some contribution theory, right?
Yeah.
All right. Yeah. And then A says, well, now that you're in the case, I'm going to assert a claim against you.
Okay.
But they can't because it's in violation of 1332. So it means, in other words, they're either not diverse or the jurisdictional amount is not met.
Okay, because I just have a note, which is what I'm going to scratch this out. It just says, after a pleaded third person, they made party, they bring claims against others and plead others. Got it.
Right.
Original plaintiff can also file a claim against third party and pleaded defendant, I guess,
Correct.
if it relates to one of plaintiff's original claims.
Correct. As long as, but the court still has, that has nothing to do, though, with whether the court has subject matter jurisdiction to hear
And
it.
that's my fault.
Yeah.
That's the question.
Yeah. So, I mean, the question is, it is entirely true
Okay.
that A case, if we make this Indiana. So now, we got no problem, right? If the original plaintiff, C gets third partied in, A asserts a claim against C, we got no problem, right?
Right.
Assuming we're greater than 75.
Okay.
Then, we're not even, and it's not even supplemental jurisdiction at that point, right?
Okay.
Because it's an independent basis for jurisdiction.
Oh, yeah.
So, I mean, that's the issue. The issue is, yes, this party can assert claims, but the court still has to have subject matter jurisdiction to hear it. Does that make sense?
Yeah. I just, in a situation like that, I can't imagine why A would have brought against C to begin with then.
Well, maybe they have, maybe it's my friend,
Okay. Okay, yeah, okay.
you know? Or maybe it's you know, I mean, maybe it's my friend, maybe it could be any number of reasons. In a business scenario, it's not all that unusual because this is somebody that I do business with all the time.
Oh, I see.
And this is somebody who I've done business with on a one-off here.
Okay.
I don't really want to piss them off.
Okay.
And I can get complete relief against this one. I don't need them.
Yeah.
Does that make sense? So, I mean,
It does.
this is totally a strategic choice.
Okay.
And there may be all kinds of reasons for that strategic choice.
Okay.
Okay?
Yeah, got it, thanks.
Yeah. Yeah, and that's a good question, because the important thing to keep in mind here is just because the joinder rules allow something, it does not mean that the court has jurisdiction. The joinder rules do not give the federal court subject matter jurisdiction. It just said, the procedural rules simply say, you can do this procedurally. But the court still has to have a basis for jurisdiction to hear the claim. So always keep that in mind, that just because you think to yourself, or the question tells you, yeah, they can join, but just because they join under the rules and that's proper, there may not be jurisdiction. So always keep that in mind, that those are two separate things. The rules of civil procedure do not grant jurisdiction, ever. Other questions that we go? Yeah, sure.
With class actions, mainly going to be all about whether or not they can actually be a class, correct?
Yeah, I mean, yes.
To focus on that?
Yeah, I mean, I think the issue there is going to be if it's there at all. Because, again, it's one of those areas that's difficult to ask questions about. Unless they ask you questions and give you everything and say which of these is not, basically. So, I mean, when you think about class actions, I mean, here you've got, well, first, the sort of 23A test. Basically, do you have typicality? These may not be in the right order, but commonality, which always sounds the same. Oh, numerosity. And representative. Someday you too will have these rules memorized.
Like today.
Like today. But when we think about whether or not a class can be a class, we have to ask, are there enough people in the class? And that can be pretty low, but that's one of the issues. Numerosity is an issue. Are there enough? Because if it's only 10 people, then isn't it just as efficient to join them all under Rule 20 and just proceed that way? But where there are 100, that suddenly the dynamic changes. The other trick place where, and this is where, for purposes of subject matter jurisdiction diversity question, for the most part, Class Action Fairness Act kind of changes this a little, but what you're focused on are the domiciles of the named plaintiffs. And so the question then becomes, are there enough? Are the claims of the named reps typical of the class as a whole, or are there some real differences between them? Because if there are, then how can we adjudicate? Are the questions of law and fact in the case common to everyone? And here is two, basically. One are the named plaintiffs in a position financially and otherwise to represent the class as a whole, and are the lawyers representing the class as a whole qualified to represent them? Those are the two inquiries under this. So that's the sort of 23A question. The other issue is, which may come up, would be where you've got various types of classes, right? So you've got a class 23B3 class where what you're seeking, the damages are money. In a money class, 23B3 money class, where what you're seeking is cash, then there has to be notice to the absent class members and an opportunity to opt out. And that's another thing where you could clearly frame a multiple choice question there. So if you're given a class where these people are suing as a class seeking money for damages to their property or whatever, and the question gives you some question about whether or not notice is required to the absent parties, the answer is yes, and an opportunity to opt out. Whereas if it's an injunction class where what I'm seeking is on behalf of these property owners to stop the polluter from polluting, then there's not a requirement for notice. And the reason for that is the assumption is whether you opt in or opt out doesn't matter. The relief is going to be the same. Whereas if we're seeking money damages, you may think your money damages a whole lot more than mine, and so you may want to pursue that on your own and rather than being part of the class. And we need to give you that opportunity. So that's one area where you could see a multiple choice question about notice in the class context. So keep that in mind. Other questions? Yes?
So a couple of the multiple choice questions I've answered, they start with like a lawyer brings a class action for like 4 plaintiffs.
Yeah.
Why do they use the language class action when there's only 4 plaintiffs and traditionally like the federal rules require the 100 or more?
Yeah, I mean, what's the question getting at? I mean, is it a class action question? Or is it a question that's just having to do with something else?
No, it's usually a question of can the federal court hear the case in general.
Like whether there's subject matter jurisdiction or...
Yeah. I think one of them, it was like all 4 plaintiffs like separately had over $75,000 in damages, and I think only one was from a different state than the defendant they sued.
Well, where the number matters, and which maybe what they're trying to do is that complete diversity is in a small class like that. And again, it would be rare that you would certify a small class like that. Unless they're talking about the 4 as being the named plaintiffs.
Oh, maybe.
I mean, if that's what they're talking about, that it's a class, but these 4 are the named plaintiffs. Which still would be the same analysis about whether there's subject matter jurisdiction or not.
Yeah.
Because the only reason the number really matters and the amount matters for that purpose is the Class Action Fairness Act modifies the complete diversity requirement for big class actions, but I don't think they'll ask that. But if you see a huge class action that's like over 100 and over like $5 million, big one. Then minimal diversity may be all that's required under the Class Action Fairness Act. And I'm not sure whether they cover that in the bar review stuff or not. I haven't looked at classes in a while. Do they? Okay. So if it's a big class, you've got a question where it's a big class, then Congress basically sort of relaxed the complete diversity requirement and only minimal diversity, which would mean in the case that, like you talked about there, that as long as one of the named plaintiffs and the defendant were from separate states, even if the rest were not, that would still be fine.
But if it was just those...
Just a normal class action. Well, a normal non-CAPA class action, then yes, they all have to be diverse.
Got it,
okay? Yeah, so they didn't change the diversity requirement for all class actions, only for those great big ones.
Yeah.
Mainly to allow corporations to get those great big ones into federal court. That was the purpose. Very business friendly. Other questions? Everybody feel comfortable with sort of basic subject matter jurisdiction stuff? In terms of federal question, diversity, that kind of thing. Everybody domicile, all of that stuff. All right. What else? I'm trying to think what other on my list here. Venue, everybody feel comfortable with venue? Transfer? Transfer of venue? Well, remember that if the venue originally is proper, the case can still be transferred for the convenience of the parties. And that's where we get into that whole issue about, where the witnesses are and all of that. If venue is improper to start, then the court can either transfer to a venue that would have been appropriate or dismiss. Normally, they're just going to transfer. Yeah?
If they dismiss for improper venue, is that with prejudice?
No.
Okay.
And that would be the thing, would be, for some reason, the plaintiff says, hey, don't just transfer us, we want to think about what we want to do now. So just dismiss us and if we want to pursue, we'll bring it back later. More often than not, the court's just going to transfer it to a proper venue. And also remember that if you've got questions, everybody should know this, but I'm going to say it anyway. If you're in state court, there's no transferring across state lines. So if you're in a state court somewhere and they're talking about transferring a case from Ohio to Kentucky state court, cannot happen. No way. Only federal court can we transfer across state lines. Everybody feel okay about sort of basic pleadings and Rule 12 motions, that kind of thing? Because that's another area where they'll kind of sometimes play around with as well. Discovery. Everybody okay with discovery? Privilege.
You want to do all the Rule 12, the final 12?
We could do them all. Well, let me talk, before we do that though, let me see how much time we have. We're almost out of time. So let me talk, somebody mentioned preclusion, so let me talk about that for a minute. So here what we're looking at, and again, in the multiple choice context, it can't get too complicated. So the thing you're looking for, if you get a question asking whether preclusion applies, is, are the same parties involved? And was the issue that is you're now seeking to exercise preclusion on in the because you're always going to have a second lawsuit, right? That's where the issue is going to come up. And so the question is, are they the same parties, or arguably are they agents? Is there a way to tie them in that way? And was the issue truly litigated and determined in the prior case? And that's where you're going to have preclusion. And where it gets, for example, let's say this is a question they love to ask, or some variation on it. A sues B. A sues B for some negligence claim. We're in a state that has pure contributory. B is found to be contributorily negligent. And therefore, well, no, A is found to be, sorry. A is found to be contributory negligent. So A is barred from recovery. All right, then B in a subsequent suit sues A, claiming negligence. Does the finding of contributory negligence preclude A from now defending that it was not negligent?
Yes, if it's the same transaction.
It's the same transaction. So I mean that's one you want to think about, because that's the kind of question where they will play around with the preclusion stuff as to whether or not whether there's significant enough difference between contributory negligence and because think about it here, who has the burden here to show contributory negligence? B does, right? So here though, but are we showing that you were contributorily negligent in a way that makes you liable to me? It's a different test, right? Because all I'm saying is that you contributed to your own harm. I'm not saying anything about whether you contributed to harm for me. So it's not actually the same issue that was litigated in the prior case. And so in this case, I think what you would see, and I think this is the way most of the practice questions come out, is that this would not be a situation where preclusion would apply. But that's what you have to look for, those kinds of scenarios where the court's going to, where the question will play around with that stuff. Because they love those kinds of preclusion questions.
preclusion would be if A then sues C, if there's.
Correct. Yeah, but again, the question would be, you'd have the question about same parties and same issues and all of that, whether it was adjudicated. But yes. Or sues same transaction, maybe a different theory of liability. Were there factual findings in the prior case that now cannot be litigated in the second case? You know, that you were actually the owner of the car, let's say.
So that would that be issue?
That'd be issue preclusion, yeah, as opposed to claim preclusion. This would be claim preclusion. Issue preclusion is generally factual. When we're talking about, you know, there's been a question of fact that has been adjudicated in the prior case, now you can't adjudicate it again. So, we out of time?
Yep.
Okay. I shall return.
Guys, if you need to take a short break, please do so now. Before we get started.
It'll be good to
Mhm.
walk. What? It'll be good to walk.
A to C for a federal question.
Yeah.
Okay.
Because then there's an independent basis, right?
Yeah.
I mean, at that point, we're not talking about supplemental jurisdiction at all.
Yeah.
So if we've got an independent basis, I mean, for example, if they're from different states and we're granted San Diego County, we're okay.
Yeah.
So either way, as long as there's an independent basis for the claim, the only place where we have to worry about it is when there is no independent basis. The only way the court can hear that is under subpoena.
And it wouldn't matter that the federal question had nothing to do with it.
No, no
all the time.
Or would it have to arise out of
I'd have to look at the rule. I think the way the rule reads that once the third party, we'll look at what, I think the way the rule reads that C can assert an issue that arises out of San Diego. I think that's true going back.
Okay.
Now, once you've got, now the thing with it is, once there's a basis issue on A, then Rule 18 would allow C to tag on. And the thing is, but I've mentioned that, I'll do that one. Because I think that the way the rule reads is that this claim would have to at least arise out of San Diego. Okay. But that could be a federal, this could be a federal question, right? It could be violation of federal law.
Yeah.
So related to whatever it is we're talking about. Okay.
Thank you.
Yep.
I doubt you're right. Like a long time ago, like back in January or something, I was talking to you about the lawsuit against the hospital.
Oh, yeah.
If anybody comes to you with the same problems, they never even ask. I
Really?
gave them all the paperwork and it was totally fine. Like, no follow-up whatsoever.
Oh, wow, well, good.
Down the line, somebody else has a similar issue.
All right, thanks.
Probably not a problem.
Thanks for letting me know that.
They left you.
Yeah, did that make sense? I mean, I wanted to talk about it again.
In the context of the
Right. Okay, good. Yeah.
I think I was caught up in the semantics.
Yeah, and I think it's, because logically it makes sense that B ought to be able, if B thinks they're liable, they ought to be able to bring them in. It just, instinctively it makes sense. The rule just doesn't allow it. So. If you have other questions, feel free to email. Yeah.
Guys, if you have not signed in, please do so at some point today.
Okay, we get out of here. Go back down in. Okay.
No, I think I got my mom.
Yeah.
No, actually, that was, no, that does not mean the whole thing, that means you goodbye, you goodbye.
Yeah, they feel
Goodbye. You two, they love you. I'm just saying, we have a question. I mean, our versus pro class of something. Sorry, we have a bare minimum understanding.
And it is very, very minimum.
Are you gonna get a pen?
Yeah, I know, I got a pen.
What? Nope, it's fine.
Did those times work for you?
Yeah.
Shot, sort of dropped the ball.
Raisin had a Ohio license plate, so is she a resident of?
Yeah.
What? She's an Ohio license? She's resident here.
She has an Ohio license plate.
That's new.
When you move across the river, don't tell your friends.
Yeah,
How does she have an Ohio license plate?
I don't know. Maybe you saw a car like hers. There's another one just like it. Hers had a Virginia plate for a really long time.
Oh, really?
And then I think she has Kentucky now because she was at
Did she go on Tennessee or?
yeah, she was really easily fast, like within 5 points.
No.
Yeah. It actually might have been like 3 points. It was like real close. She was so nervous that she wasn't gonna do well because she like rushed through her MBE.
Really?
Yeah, but apparently that's what you need to do. Carly took her time and
All right. Does everybody have a test booklet?
She left.
Is everyone ready to begin? Coming back?
Oh, yeah, she is. She's like, she just doesn't want to take this.
Yeah, back in that.
She marches to her own. Anyway.
All right, you may begin.
I didn't know there was
Right.
anything.
Okay.
You did?
But yeah, that's the only way she'd get a license plate in her house.
I just saw sitting over here, that's fine.
Somewhere in Claremont County.
Where is that?
It's Amelia and those areas, so it's like East Beach. Oh, it's not far. No, it's not like I mean, it makes sense. She wants to eventually get licensed in Ohio, but
I need to like get these.
I couldn't remember if he was a thing. Remembering funny stuff, I was like, I texted her.
Yeah.
Told her she didn't have to.
But what?
That she didn't miss it. We'll see when we might read it.
Alright.
Isn't there a number 0?
Yeah, there is, and I don't know if this is.
Yeah.
Would you mind reading out the answers, so what
Yeah.
they are?
Yeah. Yeah. You all have the questions, right? Alright, so I'll just go through. Alright, so might as well start at the beginning. Question 0. The correct answer for question 0 is B, an interpleader action. If you have questions about that, ask me as we go. Did most everybody get that one? If not, do you know why? Okay, let's talk about it then. Let's just kind of go through it. All right, so you're an in-house counsel for an insurance company. One of its life insurance policyholders has recently passed away, and each of his 3 children claims the right to the proceeds from the policy. So we've got a pot. There's people fighting over the pot. So which type of action would you bring on the insurance company's behalf? Why is A wrong? Anybody? What we talked about impleader, right? What's an impleader? How many people put impleader? An impleader is the third-party complaint that we talked about under Rule 14. It's Rule 14, impleader. We talk about interpleader, which is the correct answer. Interpleader is where, in this case, the insurance company would simply file a cause of action and place the pot of money with the court and would say, while we are the nominal plaintiffs and they are the nominal defendants, we really have no interest in this pot of money. We need you, court, to adjudicate how this money is properly distributed. So if you've got a situation where it's a pot of money, usually a pot of money, that's where you're going to see an interpleader action filed under Rule 22 or under the federal statute. There are 2, and I think they talk about this in the bar prep materials, that there's the Rule 22 interpleader and also the statutory interpleader. All right, number 1, since we've gone through question 0, number 1, the answer is B. Did everybody get that one, or how many people? Everybody got that one. All right, good. If you missed it and you want to talk about it, just let me know. Question 2, then, the answer is D. Everybody get that one? And that's one of those that sort of, there's not much really to question about it because the federal courts just have no jurisdiction over domestic relations matters, period. Those are all state matters. The Supreme Court decided in Ankenbrink a while ago that was the case. All right, so then let's look at number 3. The correct answer to number 3 is C, yes, because the woman's initial claim was for only $60,000. People Get that one? Does that make sense to everybody? All right, cool. Like I say, if it doesn't, stop me and we'll talk about it. Number 4, the correct answer to number 4 is B. No, because the claim does not exceed $75,000. I got that. Any questions?
I got it.
Okay, let's talk about it then. To avoid an accident with a motorcyclist from state A, truck driver from state B drove his truck off the road, damaging the front porch of a home in state C. Immediately after the accident, the truck driver and homeowner got in a heated argument, and the truck driver assaulted the homeowner. All right, so the homeowner sues the truck driver, and let's see, motorcyclist, homeowner is from where? State C. And the truck is from state B, right? So, homeowner sues seeking $50,000 and $30,000 caused by the assault. Truck driver then impleads the motorcyclist, alleging that the motorcyclist's negligence caused the truck to swerve into the porch under the law of state C, and the amount is $50,000, right? So we got the motorcyclist in. Then the homeowner, this is back to our supplemental jurisdiction that we talked about before. So the motorcyclist is from where? A. All right, so remember what we said, that if there's a claim by a plaintiff against the person made a party by Rule 14, and the exercise of that jurisdiction would violate 1332, which means both diversity and amount in controversy, the court cannot hear that claim. So in this case, then, because it doesn't exceed $75,000, they're diverse, right? But you don't have the appropriate amount of controversy. So because there's not $75,000, then the federal court can't hear that claim. Does that make sense? All right. 5, the correct answer is C. Grant the appeal because the State C Southern District Court lacked subject matter jurisdiction. Does that make sense to everybody? Any questions? All right. Number 6 then is D. No, because the court may invoke supplemental jurisdiction since complete diversity of citizenship is satisfied. Everybody get that one? Questions about it? Okay, good. Number 7, the correct answer is C. The homeowner commits the action in a state A court. Any questions about that one? Questions? Nope. Yes.
So why wouldn't B be the most?
Well, let's talk about it then. All right, so homeowner from state A hires a contractor from state B to build a vacation home for her in state C. The party signed a contract in, am I on the right question?
Yeah.
Okay. The contractor breached the contract, the homeowner sued in a court of state A seeking damages of $100,000. Contractor removed the case to federal court for state A. Homeowner promptly moved to remand the case to state court, arguing that venue was improper. Which of the following facts is most relevant to the court's decision on the homeowner's motion? Well, venue is proper, right?
Yeah.
Even though it wouldn't be proper under the statute, but remember that the removal statute creates its own venue. Because the removal statute says the only place you can remove a case to is the federal court that encompasses the place where the state court sits. Even if venue there would not have been proper originally, which may well be the case as here. Does that make sense? Okay. Other questions on that? All right, number 8. The answer is D. No, because the counterclaim lacks a separate basis for subject matter jurisdiction. Questions? All right. Number 9. The correct answer is B. No, because the subcontractor's claim did not arise from the same transaction or occurrence as the plaintiff's claim. Questions on that one? Number 10, the correct answer is D. In state C or D only, because only those 2 states have personal jurisdiction and proper venue. Questions on that one? I understand why that is the answer. If not, say so. All right. Number 11, the correct answer is A. Yes, because the action was not timely filed under state A law. Sure, and this is the one that I talked about, one of those like I talked about when we talked about where you'll see an Erie problem. That if it's an Erie problem and the question focuses on the statute of limitations, the state law is going to always apply. Even though, in other circumstances that the analysis might be different. But the way the Supreme Court is held in the statute of limitations cases, that the state statute's always going to apply. And so that's really what you've got here, is you've got a situation where it's an Erie question, you apply the federal rule, case gets to go forward, you apply the state rule, case goes away, which do you apply? Because it's statute of limitations. And primarily because the Supreme Court has held that the statute of limitations is a lot closer to being substantive than it is procedural. Because it's part and parcel of the substantive claim. And that's why the courts come out there. Does that make sense then? Okay. Number 12, the correct answer is B. The restaurant may not include the ice cream shop because the claim is not a proper third-party claim. Everybody get that one? Question? And that's one of those like we talked about here, where, basically the original defendant is saying, hey, there's somebody else who's liable here, but who's liable to the plaintiff. All right, 13, grant the motion because diversity of citizenship does not exist. Did I get that one? It's one of those situations where what citizenship does the representative of the executor, representative of the decedent, take on? It's also true, just since we're talking about it, it's also true with children. So keep that in, because you'll see those kinds of questions too, where it's a representative for a child, the representative lives in a different state, but the representative takes on the domicile of the person or entity that they're representing. 14, B, the federal law should apply state B's choice of law rules to determine whether state A law or state B law governs. And this was one of those theory types that we talked about in terms of the Claxon choice of law issue, where they give you the choice that you can apply this law or that law, and without more in this question, all we can say is that we've got to look to the conflict of laws and rules. That's all we know. Any questions on that one? 15, the answer is D. Yes, because the bank's executive offices are located in state A. Anybody? Questions? Yes.
So, my question is, the bank's only mentioned in like the second sentence, and then it's nowhere else in the problem.
Mm-hmm.
Why does that matter for this question?
Let's see. Let me read through it real quick. Identity thief broke into a manufacturer's data storage facility, accessed the private information about its customers. Thief used the information to take a loan from the bank in the name of one of the customers. The customer sues the manufacturer in state A, right? In his complaint, the customer demanded damages in excess of $75. In his complaint, the customer also alleged that a recently enacted federal statute restricting damages to actual damages does not preempt the state statute because the federal statute was unconstitutional. The manufacturer's executive offices are in state A, but its sole manufacturing plant and data storage facility are located in state B. I think that's a good question. Where does the bank come into play here? Because the bank's not in the lawsuit, right?
No.
Am I reading this right? What is the answer? I think that's right. I think it's a typo. Because, I mean, that doesn't make, because the bank's not in the suit. So it's actually it's the manufacturer, yeah. Because the problem here is that you've got removal based on diversity, right? And it's a violation of the home state defendant rule. And also what the question is testing is whether you'll fall for the fact that it argues that it's a federal question based on the defense.
But isn't that on the face of the customer's complaint is the federal question?
But that's as to damages, right? It's not as to it's not as to the cause of action.
Okay.
So it's not as to the cause of action, it's as to damages. So it doesn't form the basis for the court's jurisdiction. So the question, and that bank thing clearly is just a typo. It should be the manufacturer's. Does that make sense? Okay. 16, the correct answer is A. All legal claims should be first tried by the jury. Yes?
This one goes back to 15. Do they have, does the court have funding stated?
No. Because the statute restricts the court's jurisdiction in that circumstance.
Okay.
Because the statute specifically says that if the defendant if the basis for the federal court's jurisdiction is diversity, and any of the defendants are a citizen of the state where the case is filed, it cannot be removed. So the court doesn't have jurisdiction. Any questions on 16? Okay. 17. The correct answer is B, only in the Northern District of State B. Questions on that one? Yeah.
Why couldn't you bring, I chose B, so why couldn't you bring it in B, C, or D? Because they're all different citizens.
What does the statute say? The statute says that all defendants have to be from the same state if you're going to bring it where the defendants reside, not where any particular defendant resides.
Oh, okay.
So because they don't all reside in the same state, then where the defendants reside is not an option. So our only option then becomes where basically did all the acts or omissions giving rise to cause of action occur. So if you've got multiple defendants, they all have to be from the same state if that's going to be the argument as to be. Any other questions? All right. All right, number 18. The correct answer is C. Deny both motions to dismiss because under the federal rules, the action was commenced when the complaint was filed. So basically an amendment question here under Rule 15. Any questions on it? Okay. All right. Number 19. The correct answer is C. State A does not recognize any exceptions to the doctrine of mutuality. Sure. So basically, let me read through the facts real quick. It's been a while since I was through these. A truck veered off the road in State A, seriously injuring a pedestrian who was a citizen of State B. Pedestrian sued the truck driver, citizen of State A, in the federal court for State A, alleging that the truck driver's negligence was the sole cause of the crash. After trial, the jury returned a verdict in favor of the truck driver, finding that the truck driver was not negligent. Thereafter, the pedestrian commits a second action in the federal court for State B against the owner of the truck, who, like the truck driver, was a citizen of State A. Pedestrian alleged that the truck driver's negligence was the sole cause of the crash and that the owner was vicariously liable. In his answer, the owner asserted the defense of issue preclusion. Shortly thereafter, and before discovery commenced, the owner moved for summary judgment against the pedestrian based on the verdict in the prior action. So if we think about that from the standpoint of preclusive effect, we don't have the same parties, right? Find the question. Has anybody got the answer in front of them? I mean the explanation. I'm trying to see how they explain it. Because I want to make sure that I'm consistent with what they say. You have it? Okay, good. I can't find it here.
I know, it's really confusing.
I know. Okay, great. I'll bring it right back.
You're fine.
All right. So here's the issue that normally in the majority of jurisdictions, here they would be allowed to assert issue preclusion defensively because they're basically the same cause of action, in essence, basically the same party. Here, though, because the owner was not a party to the prior action and not in privity, because there's no contractual relationship. I mean, it's a vicarious liability claim here. That under mutuality requires that that the parties be either the same or in privity with each other. And here, though, because the court denies the motion, the most likely reason would be because the state doesn't recognize any of those exceptions to the doctrine. Does that make sense or no? Because the preclusion stuff is you got to think about it. Are they the same party? Is the same issue being litigated? Here, they're clearly not the same party. But in most cases, in most jurisdictions, as long as there's final judgment in the prior case, the issue was actually litigated, which it was here. It was essential to the judgment, which it was. And the party to be bound by the prior judgment was either the same party or party in privity, then we would be okay, normally. But here we've got a state that doesn't recognize that. So let me give you your answers back. Maybe I can figure out where to name it. All right, let's see. What's the next one? 20. The correct answer to 20 is D. Yes, if the defendant waives proper venue. I got that one. Questions about that one? All right. 21. The correct answer is B. The university should file the notice to remove the entire case in federal court, but the federal district court will remand the state law claim back to state court. Because remember, when we're talking about removal, you can't remove part of the case. The whole thing goes, and then the court will sever it and send it back. Number 22. The correct answer is B. Yes, because the action complained of acts are not part of a single transaction or a series of related transactions. Questions? Yeah.
So this is just because there were two different defendants that did two different things, regardless of the issues were very similar.
Mm-hmm. Yeah, because if you've got suits against, I mean, if they're not the same cause of action arising out of the same transaction, or at least series of transactions, then it's going to be pretty hard to try them together. Number 23, the correct answer is A. No, because the action does not arise under federal law and the parties are citizens of the same state. Everybody, okay. Number 24, the correct answer is C. Deny the motion, but it should transfer the case to the Eastern District of State B. Any questions? Yeah. Okay, 24. Let's see. Plaintiff is a resident of City A, located in the Northern District of State A. Defendant is a resident of City B, located in the Eastern District of State B. Defendant negligently ran a red light in City B, resulting in the collision between his car and the delivery van that the plaintiff was driving. Result, 100 pounds of court that plaintiff wound up striking him in the back of the head, causing severe injuries. The plaintiff sued the defendant in the Northern District of State A. Defendant moves to dismiss based on improper venue. Is venue proper in the Northern District of State A? Why?
Because the defendant isn't a resident there and the cause of action has to be.
Right, right. So, I mean, here the question is, I mean, the plaintiff is there, right? But we don't care. The plaintiff, it obviously has its choice of venue, but it can't choose a venue that's improper. And on these facts, we've got a single defendant, so wherever that defendant resides would be proper venue. And then wherever the cause of action or the acts and omissions giving rise to the cause of action occurred, that would also be proper venue. And in this case, they're both the same. And so the case is filed in the wrong place, right? But transfer.
Is that why C is the better answer than A, is just because the court should transfer it?
Yeah. Okay. You know, and these questions can be and they will be tricky and sometimes stupid and, you know, sort of ridiculously nuanced. You're going to miss some, you know, I mean, you know the stuff, you know it. So, you know, if you miss one here and there, it's okay because that's what's going to happen. I mean, it's just going to happen. None of us are going to get all these right because some of them are tricky and they're intended to be tricky. And you're moving at a really rapid pace through them. So, I mean, if you miss one or two here and there, you did. Don't worry about it.
I'd be happy with missing one or two.
Right, exactly. All right, number 25. The correct answer to 25 is A, yes, because there is proper federal subject matter jurisdiction. Anybody got questions about that one? Okay. 26. The correct answer is B. Yes, because the cross-claim arose from the same transaction or occurrence as the plaintiff's claim against the company. Everybody get that one? Okay. Yeah, the thing to remember always about cross-claims is cross-claims have to arise out of the same transaction or occurrence as the original cause of action.
And you don't need diversity or anything like that.
Depends. Usually, as long as because it has to arise out of the same transaction or occurrence as the original, and it's not a claim by a plaintiff, then you're normally going to be fine. Because supplemental jurisdiction is going to cover it. All right. Number 27, the correct answer is B. The defendant is a citizen of State A, and the plaintiff is a citizen of State B. Questions? Okay. 28, the correct answer is C. Yes, because the reporter is not a citizen of any state, and he is not an alien. Yes?
So in a question like this, how long would a person have to be, I guess, gone in order to no longer be considered a resident of where they were previously?
Well, what's the test for domicile?
Permanency.
No, physical presence and intent to remain.
Okay.
So if my intent is to remain wherever it is I am, that's my domicile. Yes. You'd have to go wherever he is. Or you could sue him in state court, right? You could always sue in state court. Because you don't have the problem of subject matter jurisdiction in state court. Now the problem would be in state court having to, would obviously be tracking him down to get him served. But as long as you got him served, you could sue in state court. But not in federal court. Yeah, so again, it's a situation where it's not that the claim disappears. It's just that you can't bring it in federal court. Yeah?
But if this was lack of personal jurisdiction, would that be okay? Like, to serve him in that way?
Well, you mean if we're in state court? We can't be in federal court, period. So you mean if we're in state court?
I mean, I guess the question did ask about federal court, but it says the reporter moves to dismiss for lack of personal jurisdiction. No.
If it did.
Oh, I'm sorry.
So you didn't have the option. Oh, okay. Do we serve him or not? I mean, it would depend, right? Which is why personal jurisdiction questions are hard for multiple choice questions. Because we've got all that contact stuff. We don't know what his contact is. And does his contact with the state in question give rise to the cause of action here? Because if it does, it doesn't matter whether he's a citizen or not, right?
Yeah.
It may mean that we can't be in federal court because he's not a citizen of any state, but it would be a question in state court where he could have sufficient contacts that the state would have personal jurisdiction over him. You just have to sue in state court. So you could have, personal jurisdiction and not have subject matter jurisdiction in federal court. Any other questions on that? Number 29. The correct answer is C. The court has declined to exercise supplemental jurisdiction. Question? Okay. Yes. Sure. So following a mid-air collision, a passenger in one of the planes, a citizen of State A, sues the FAA in federal court under the Federal Tort Claims Act, alleging negligence on the part of its air traffic controllers. So how are we in federal court then? What's the basis for subject matter jurisdiction? Federal question, right? So we're there on federal question. The passenger also names the pilot of the other plane a citizen of State A as a defendant for a claim based on state law negligence. So remember what we said about the trick that they're trying to play here on this question is that here we have a defendant to be added who is non-diverse, right? And it's a claim by a plaintiff against a party joined under what rule? How did we get these two defendants together? Rule 20, right? But it doesn't matter here because the basis for the independent basis for subject matter jurisdiction is federal question and not diversity. So we never get to that 1367B analysis. We never have to ask those questions. Now, the court always has the discretion to not exercise supplemental jurisdiction. It doesn't have to. But here, because we've got a claim against a non-diverse defendant that arises out of the same transaction or occurrence, but the basis for the subject matter jurisdiction of the federal court is federal question, then all of those exceptions of 1367B to supplemental jurisdiction don't matter at all. It only matters, whereas if the situation here was that we were suing, let's say we're not the government, we're just suing the airline on a basic state law tort claim, state law negligence. So the passenger is a citizen of A, let's make the airline a citizen of New York and Delaware. And let's assume it's over 75,000. So the basis for our jurisdiction is diversity now, right? Now, if that same plaintiff, a citizen of state A, wants to also sue that pilot, who's also a citizen of state A, can the court hear that claim? No. And here's why. Because if we think about it for a minute, if we've got, okay, our plaintiff is a citizen of state A. Our plaintiff wants to sue the airline, which is New York and Delaware. That's okay, right? We're assuming greater than 75K. But plaintiff also wants to sue pilot, who's a citizen of A. Now we've got a claim. Now the basis for federal subject matter jurisdiction is diversity. And in order for the court to be able, and this arises out of the same transaction or occurrence, but now we have to look at 1367B to see if the court can exercise supplemental jurisdiction. It's a claim by a plaintiff against a person made a party under Rule 20 in this case, the exercise of which would violate 1332 because they're not diverse. So if you change the facts there, then no, the court can't hear it. But because the basis for the original claim is federal question, then the court can exercise supplemental jurisdiction, because if the primary basis for subject matter jurisdiction is federal question, we don't care about all those exceptions under 1367B. They just don't come into play at all. So when you have one of those questions where it looks at, where it's a question of exercise of supplemental jurisdiction, one of the first things you want to ask yourself is, what is the primary basis for federal subject matter jurisdiction here? Because if it's federal question, the only thing you have to worry about is, does this supplemental claim arise out of the same transaction or occurrence as the original claim? It's only when it's diversity that we have to get into all of that stuff under 1367B. Does that help? Hopefully. Other questions? All right. So that was 29. 30. The correct answer is A, lack of subject matter jurisdiction. Question? Okay. (31). The correct answer is C. The gas worker's claim against the electrician is not a proper third-party claim. Any questions on that one? And I will say that you've seen two of these questions in this set. These questions with third-party claims under Rule 14, that's a question you're going to see multiples of. Because it's easy to trick people into saying, well, yeah, of course, it's joint tortfeasor, we can bring them in too. But you can't. So watch out for those. 32. The correct answer is D. Only the finding regarding the skateboarder's negligence has preclusive effect. And the reason for that is, on this question, is because the finding of contributory negligence in the original action was essential to the judgment. The finding as to negligence for the other party was not. That's all of it. Any questions anybody has on, want to revisit any of those? I will say, as you guys are preparing over the next month or so, if Civ Pro questions arise or other questions that I might be able to help with, feel free to either, I'm teaching this summer, so I'm around. Also working on a couple of amicus briefs and an article, so I'm around a bit. Otherwise, feel free to email me. I probably can answer Civ Pro questions and torts questions. I can't answer contracts and property. I wouldn't want to take an effort. I might be able to answer them, but I don't know that it would be reliable. But any of the other stuff that you're looking at, or family law type issues, or remedies issues, any of that kind of stuff, feel free to reach out, because I want to do what I can do to help you guys. I know it's no fun, but hang in there. It will be over, and you want to just do it and be done with it. So good luck. Good luck, everybody. And just keep at it. I know it's hard, but just keep at it. And like I say, if you have questions, just ask me. I'm happy to try and help. Or if you come across, if you're doing some questions like this, and you come across some answers that just don't make sense, then don't sit and think this makes no sense to me. Send me the question. If it's a question I can answer, I'm happy to sort of exchange emails with you and try to explain it, or set a time where we can sit down and talk about something. Because usually these questions as they come up, there are going to be, particularly practice questions, there are going to be questions that you're going to see sort of at least in some form more than once. So you want to make sure you kind of get an understanding of it, so that when it comes up again, you know exactly what the question is. I know that. That's not tricky anymore. So anyway, thank you all. Good luck. Absolutely. Glad to do it.